Bonjour, good afternoon. I will, for our speaker, switch to English right away. My name is Nicolas Vermez. Welcome to everybody in the room and welcome to everybody online to this, the last lecture of our series on spaces of justice, right? Les espaces ou les endroits, les lieux de justice. It's not fair to our other lecturers to say we kept the best for last, but we're finishing very strong. There's a more politically correct way to say it, with a wonderful lecturer, somebody that whose work I've been following for many years, who is the author of a certain number of books on legal architecture. This one from a few years ago, Legal Architecture, and this recent one, which I believe she'll touch upon in her presentation, The Democratic Courthouse. I am, of course, referring to Linda Mulcahy. Linda is the professor of social legal studies, as well as the director of the Center for Social Legal Studies. She holds degrees in law and legal theory and sociology and in art history, only that. And has taught in numerous institutions, including the London School of Economics, Birkbeck, has worked with the Law Commission and Bristol University as well. I could just for the next 45 minutes just read her quite impressive CV, but I'll simply refer you to on her website to go and see all of the amazing work that she's done. And instead of wasting time reading this, I think we've all rather listened to her. And so without further ado, I will cede her the floor and share the screen for her at this time. And so, Linda, if you will.
Thank you. Thank you so much for inviting me here, and it's actually lovely to be here in person, which is sort of relevant to quite a few things I'll be saying tonight. The dynamic in the room is always different when you can see people and smell them and touch them, it seems to me. I'm going to be touching on my last two books a little bit in the presentation, but one of the problems that I have is that I'm getting on now, I'm getting quite old, and I almost have too much in my head about court architecture. So what I'm going to do is I'm going to draw on some of the work that comes out in those books. But actually what I want to do is take the talk one step further. It seems to me I'm in the city that hosts the Cyber Justice Lab. And for that reason, it's quite important, I think, to ask, how does our attitude towards the architecture of courthouses change when they are being dematerialised? We have pretty much in the last 3 years in the UK closed about half our courthouses, and we're set to close more courthouses. So in many senses, you could say that my research in the last 15 years has been completely irrelevant. I'm now completely out of date. All those courthouses that I visited all around the world was for nothing because we're in a completely new era. But one of the things I'd like to do tonight, and it's the reason why the image of Janus, which was on the first slide, becomes relevant, is I want to look backwards in order to think, what do we need to remember about courthouse design? What can we learn from, in the case of England, 700 years of consistent thinking about courthouse design? What can we learn that we need to take forward, and what do we need to forget about what we've done in the past? So I wanted to start really by asking why you should care about courthouse architecture. And it seemed to me, first of all, that most developed nations are at a critical point in terms of not being quite clear. Is it this one? Thank you. Not being quite clear how much real face-to-face interaction we want. How often and for what cases do we actually want to gather in a room? And for what cases do we think it's appropriate for us to go completely online? And which are the cases where we need a hybrid format? And that's a question that we have not answered in the UK, but is a really, really burning issue for the Ministry of Justice at the moment. The second reason, so I think we're at a critical moment, and Janus, as you will probably know, looks both forwards and backwards. So it's always a really important symbol for thresholds. And it seems to me we're at a really critical threshold at the moment. Seems to me that mature democracies, I won't speak for Canada, but I will speak for the UK, having something of a crisis at the moment. Colin Crouch has called it the post-democratic society, or the democratic deficit, so that increasing numbers of ordinary people no longer seem to have faith in institutions of government like the justice system, because they believe that those places are not for them and they are not run by people like them. So we do have a democratic deficit. We're living in a post-democratic society, and that, for me, makes it even more important for us to think about what we mean by a democratic courthouse and how we operate these institutions in ways that they're accessible. And when I talk about democratic courthouse, it's really interesting in my last book how many people reacted against the title of my book. How often when I gave presentations, they said, come on, a democratic courthouse, which I sort of thought was a rather bizarre thing. It is a branch of government after all. We do expect that they are operating within a democratic system. I accept that courthouses themselves are a combination of spaces. In England, I would think of them as a prison, as well as a place where we mete out justice, because we have cells and extensive cells below the courthouse where people are kept and incarcerated. I'd also, in an English context, call it a gentleman's club, because there are often some very fine facilities for predominantly male senior judges. And many of the Victorian courthouses on which those facilities were first based were designed with gentlemen's clubs in mind, which is one of the things that I sort of traced down in my 15 years worth of archival research. So they're multifunctional spaces, most of which are private. There isn't much of the courthouse that is public. Most of it is a private, behind the scenes space. But it seems to me that we still should be aspiring to it being a democratic space, and the public areas being a democratic space. And what I mean by that is that the courthouse architecture should somehow reflect the fact that we dignify the citizen, that we treat the system with respect and with dignity, and that we expect them to participate in the process. And I'll come back to that later on in the lecture, in the sense in which I think we are actually realising that ideal. So by the democratic courthouse, I mean somewhere where people participate, they're dignified, and that the spatial arrangements facilitate participation and due process. And I think I can prove in an English context that we failed on that latter point. So the structure of the talk then is partly looking back. What do I think we can learn about architecture, looking at 700 years of the history of ideas about courthouse design? And it's very kind of Nicholas to put along both my books, but the first book that I published on legal architecture was a rather ambitious attempt to look at the history of ideas over a 700-year period. Thank you. And the second part, I really wanted to think about looking forward. What can we learn about courthouse architecture? What do we think we can do differently when we render the courthouse digital or dematerialize it, that is better than what we've been able to do when we've been holding trials and legal proceedings in buildings? So looking back will actually form the major part of the talk. And I really wanted to refer to 5 key points here. The first of them, and I will go through these in more detail, the first of them is the power of the gathering. The power of people actually being in the same room with each other. Now, pre-pandemic, I didn't always convince people of this point, but I think post-pandemic, we do realise how important it is to actually physically be present in certain situations. A few years ago, I used to make a joke about, would we ever have a bar mitzvah or a wedding online? My niece got married in California online and televised, sent it to us on her phone. She was giggling the whole time. She had no dignity at all, that process. There were a queue of brides and grooms behind her. So, I mean, things have changed, but I think one thing we've learned, especially in the education sector, actually, if there are any teachers in the room, they will be aware how anxious we all are to get our students back in talking to us, because that dynamic is different when we're in the room together. So I wanted to talk about what we know from history about the power of gatherings. And I also wanted to talk about the civic landscape, which I think is increasingly important, but a really endangered species. Legal geographers are really interested in the ways in which the civic sphere is disappearing, that the closest we get to public space in many city centres is often now the shopping mall. That's where people are most likely to gather, not the agora, as we once anticipated these civic spheres in our centres, civic centres being so important, but the shopping centre. I think that if we look back, there is a lot that can be done in terms of political and cultural symbolism by courthouses being physically present in the civic sphere. And I also wanted to talk about the ways in which people make a very different journey to the courtroom when they are in a physical building, and the way in which that journey prepares them for their performance in the law court, and how that differs when we dematerialise the courthouse. And as one participant I was speaking to recently said, it was weird going into that online trial because one minute I was cooking pancakes for my child and getting them off to school, and the next minute I was in court. Okay, how do we deal with that different sociology of time that we seem to have imposed upon ourselves? So I wanted to talk about what we've learned about journeys. And then, because I'm a sociolegal empirical researcher, I just wanted to go all miserable on you, because one of the reasons I got into architecture in the first place was that I used to do a lot of work with victims of medical accidents, and I interviewed many hundreds of them. And I decided that it was too much of a strain. I'd start working on legal architecture because it was about aesthetics and beauty. And all that's happened is I've come out miserable again, because I'm going to talk to you about the degrading impact of many of our buildings. That there is a danger, having made all these other points, there is a danger that we are overly romantic about the building, and that's something that we also need to learn from our post. So the folly of romanticism. And I've got some fairly brutal examples there. Is there any way, Sylvian, of just moving these peeps just so that people can see the images properly? My apologies to those online. Thank you, I should have known that. Okay, so let's start with the power of gatherings. I've got a quotation here from Homer's The Iliad, and it's a section of the Iliad where he talks about Achilles' shield. And Achilles' shield describes a perfect society. And as part of that description of Achilles' shield, he talks about the perfect adjudicatory setting. And he says the elders sate on their seats of stone in a solemn circle, holding the staves which their heralds had put into their hands. Then they rose, and each in his turn gave judgment. And there were 2 talents laid down to be given to him whose judgment should be deemed the fairest. Now, he talks about a circle of stones. He's talking largely about a tribal society, so the circle is much more relevant in a tribal society. We see a lot of justice facilities in tribal societies being in the round because the power is distributed. But we've also had important rituals around people gathering to mete out justice. In a European context, in England and France, there's a long history of kings giving judgment under a tree. And the tree is really symbolic in this sense. So the trunk of the tree represents the monarchical society. We're no longer in the round. The trunk of the tree represents the monarchical society, and the branches that reach out represent the goodwill of the king in looking after his people. So a lot of symbolism in this gathering together. And in fact, I don't know how common it is in courthouses in Montreal, but in England, we still have wooden panelling halfway up the room, and we have a large canopy over a lot of the judges, still representative of that tree. And the importance of people gathering together under what was often the largest tree in the area, so people would know to go there and gather. And I found evidence in my first book of a trial still being held under a tree in America in 1867. So it's a relatively recent practice. But I think also we have references in the Bible to people meeting at the gates of the city in order to administer justice. And the significance of the gate, just like the height of the tree, is that many people would know to gather there. So the gates of the city were the places, the thoroughfares that people would go through. So I think the power of gathering together and having these symbolic exchanges, we note in Homer that the elders had a stave that was put into their hand by the heralds, a lot of ritual created around these spaces. And one of the questions that I'd like to end up with, what are the new ceremonies and rituals that we need to use in online hearings? Because it seems to me, as a social scientist, ceremony and ritual is really important. The need for it doesn't disappear just because we're operating on a screen. In fact, the coldness of the screen makes it even more important. And I've got some ideas about how we do that. I think we also need to be aware of the significance of the courthouse in the civic sphere. I think courthouses are really important places in the civic sphere. They remind us when we see a courthouse, normally in the West with a justiciar on top, that law is important and it is in our midst. I think the significance in this sense is that these buildings exist, whether or not you need to go into them. They have an impact on those who walk outside. Now, I hope you've noticed that I'm trying to please the local audience, because we've got 2 courts from Montreal. My first day, that's what I went to have a look at the courthouses, which prove these points. Different eras, very different styles of building, but they both prove the point that a lot of money has been spent on these buildings in a space that we would say is part of a civic plateau, often near town halls and transport links. One of my favourites ever, and it was on my first book, and I can't stop falling in love with it, is St George's Hall, which is at the top left, which Nicholas Pevsner, the architectural historian, calls the greatest neoclassical building in Europe. It's horrible in the inside because the architect died. He was only 24, and somebody else took over, and it goes all Victoriana. But the outside is truly stunning. And they spent about half the amount of money building that building that they did in sinking the Liverpool docks, which for England were the most important docks for most of the 19th century. It just gives you a sense of how much money was often squandered on courthouses in the 19th century in England, especially in the newly emerging cities of the north, which were rich through industrialisation. They were very keen to plough money into these big civic buildings. And the other building there is Alfred Waterhouse's Manchester Town Hall, which holds a special place in the heart of my historical heart, because it was the first building to really start segregating people in a very significant way in the 19th century. Now, I'll come back to that, but it got bombed in the war, and unfortunately, Gothic wasn't popular after the war, so it never got rebuilt, but it was a really significant building. And I think one of the things that is interesting about this is John Elms and Alfred Waterhouse, who were the designers of these buildings, were some of the most important architects of their day. Since the 1970s in the UK, we have never commissioned a prominent architect to build any of our buildings. They're building them all over the place, elsewhere outside the UK. But the 19th century industrialists really understood the power of getting the best to produce these buildings to remind us of the importance of law. So again, something we need to think about when we move towards digital is, what does that do to our sense of the public sphere? It seems to me that salle de pas perdu is also a really significant design statement. We don't have a salle de pas perdu when we have online trials. But it seems to me that there are so many instances of, again, these grand statements extending to the interior of the building. And in our English and Court Standards and Design Guide, from 1985 onwards, we always had this statement: court buildings need to be seen to be there and seen to be public, authoritative and important in society, whether an individual has reason to use them or not. Unlike our other buildings, therefore, court buildings cannot be hidden away on an industrial estate or be anonymous suburban office buildings, nor can they be seen to be high security compounds or visually oppressive. So this is wisdom then that we have acquired over this 700-year period that I've been charting. So the third point, the third thing I think that we need to appreciate from a history of court design is the significance of buildings and courtrooms and court buildings in particular in marking political, in having a symbolic function when we have political and cultural change. So on these slides here, we have the South African Constitutional Court, which some of you may know about. Albie Sachs, who with Yvonne Maguru took the lead as the 2 design judges for this. Albie Sachs very famously rejected the symbol of Justitia for that court. You will find her nowhere. And he said that's a Western symbol of justice. What we want is an African symbol of justice. So the motif throughout this court is the tree, the African tree under which Qadi justice was done. We go back to the tree again. But this Sadapapadu here is supposed to represent the tree. You've got large girders, which are supposed to be the trunk of the tree, and there are shutters on the window that are always at different angles, which are supposed to symbolize the leaves of the tree and how they sometimes cast shadow on you and sometimes don't. Now, one of the things I find so interesting about the South African Constitutional Court is it is both a symbol of change in South African society, a symbol of the fact that apartheid was over and that a new form of African justice was being born. And we see that in all sorts of symbols throughout the court, actually. And it's also a court, I think, which records the complicity of the law in the abuses of apartheid. So it's interesting itself that it's symbolic in both. It looks back and accepts the horrors of apartheid and the part that the law played in it, just as the Mexican Supreme Court does as well, actually. It has some really interesting murals there of the violence of the legal system and the complicity of the legal system in abuses in Mexican society. So a really, really important symbol there of looking back, but taking it forward towards an African form of justice. This is a court that I've never been to, and it's a tiny, tiny little place in Australia, and I spend quite a bit of time in Australia, but I've never been able to persuade anyone to take me down there. This is Port Augusta Courthouse, and they have a large Indigenous population around Port Augusta, and the Indigenous population in Australia are so interesting because they've actually mounted quite a few challenges to European courthouse architecture. And what that has meant is that designers have been forced to bring the outside in, to bring trees, to have conservatories, so that people can see the skyline. As you probably know, in the Aboriginal culture, being able to see the skyline is really important. To be able to see trees and nature is really important. And actually what has resulted is much more beautiful courthouses that everybody enjoys, because I think we all know, again, from COVID, that we're all much better if we're outside a little bit of the time and we connect with nature. But they've actually built this, this is a courtroom, and it's outside, and people will sit on very low stones and they will just have the shelter from the sun for them. So it's a more formal courthouse inside, but I think that in itself, again, is another really important symbolic act. So courthouse design can sometimes make these statements that demonstrate to people that society has changed in a way that reflects the political and cultural norms of the time. We have the German Federal Court here, which was built in the aftermath of the Third Reich and the horrors of the Third Reich, built completely in glass. Obviously, the symbolism of transparency. And you will find me probably referring to Richard Rogers a few times, but the court in the top left is the Palais de Justice in Antwerp, which was built in the aftermath of a lot of judicial corruption. And one thing that I cannot find a photo of, and I cannot find my photo of it when I was shown around that building, is that a lot of the corridors that the judges go along are actually glass. And I did that tour with a number of judges, and they were all moaning about the fact that it was a security risk, that they didn't want to be exposed. But in fact, they were being held to account after all the corruption charges against the judiciary. And I thought that was a rather nice symbolic way of saying justice and the judges who administer justice must be transparent. And we must be able to call them to account. So again, buildings can do a lot of work for us in reflecting these sort of political and cultural changes. We see this in a much more modest way, I would say, in the UK, where we had a massive court building programme from the 1970s onwards. Paul Rock, who's a fellow sociologist at Oxford, calls it a building programme that was as big as the pyramids. I think he was slightly overdoes it when he says that, but I mean, it was one of the biggest building programmes of the 20th century. And you can imagine all the building programmes we had after the war, housing, schools, hospitals, the development of the NHS, the development of the welfare state. Courts came last. They were sort of at the end of that post-war boom in thinking that we needed to recreate society in a different way, with buildings that represented much more democratic ways of doing things. So we begin to see in Waltham Forest Magistrates Court, unfortunately, is one of the courts that has been shut down. If you like brutalist buildings, which I do, and modernism, this is a gorgeous court. But what's significant about it here is it's flatter. It's flatter and it's a human size. An architect would say that that is a human size building. It's meant to be more accessible. And I would say that we had a democratic turn in courthouse design around the 70s and 80s. We then went away, that I will talk about in a minute. But we also see, Truro Combined Court is a very good example, this courtrooms becoming much flatter. We don't have what we had in England for a long time, what we call the wedding cake courtrooms that have lots of tiers, with the judge much higher than everyone else and often just looking across at the defendant and the judge are about the same height. That we went away from that. And this is a lovely little, I'm sorry to do this to you, but when you're an archivist and you spend years in the archive, I don't know whether there are any other archive nerds here, you have to show people things that you found the day that you were really cheered up after 3 days of looking at nothing. And this is a lovely little drawing that we found that somebody in the Ministry of Justice had drawn in the early 70s to just demonstrate that everything should be much more human size. And it was just lovely to see a sort of hand-drawn drawing. But a couple of significant quotations here. So this architectural historian at the time, Julian Hansen, said, the story which seems to emerge from a semantic analysis of courtroom interiors is one of a gradual shift in the space of law, from a more autocratic to a more democratic governance, from elitism to participatory justice, and from a milieu which is intimidating and awe-inspiring to one which is reassuring or even seductive. And the Court Standards and Design Guide, in a statement that we can trace back to about 1974, says the building should be seen less as a symbol of authority than as an expression of the concept of justice and equality before the law. The scales of justice are a more appropriate symbol than the sword of retribution. So this wonderful moment, I think, in English court design, where we see this shift towards a concern that courthouses should represent a modern democracy. I think there are also important things that buildings do in preparing people for their performance in the courtroom. This is something that I've been thinking a lot of, because I've been working with our Ministry of Justice and Court Service in preparing litigants for online hearings. And I was drawing very much on what I thought we used to do in physical courthouses and the way in which we help prepare people for justice. So dealing with that issue of making pancakes one moment and being in court the next, you know, does there need to be something between? I think we would all assume that there does. And I think if you look carefully at the way a lot of courthouses are designed, certainly in the UK, you can see this attempt to have an entrance that allows people to walk up to the court to work out what it looks like. Courthouses, like any public building, we would hope are readable, that you could roughly work out what's happening, where the reception should be, certainly the ones that are well designed. And I particularly like this example from Coventry, which has this sort of sweeping path that you go up. And it's interesting that the Court Standards and Design Guide that we developed in the 1970s says the main entrance and entrance hall require a civic presence to reflect the status of law in society and engender respect for the decisions made in the courts. This can be achieved by being the focus of the townscape through symmetry and formality in the architecture, through a generous use of space and height internally, and by the use of steps to the entrance. There should also be a generous external gathering space outside the entrance. The main entrance should symbolically be the image of the court and the place outside which the press photograph those seeking publicity after a case. And there's this lovely idea, I think, of a threshold here, that you approach the court and then you go over the threshold. And it's Paul Rock, in a really wonderful ethnography, 2-year ethnography of a court in London, talks about it as being the threshold between the profane and the sacred. And lots of people have likened courthouse architecture to cathedral architecture or church architecture. So that notion of going from the profane to the sacred, going from a very ordinary space to something special. And nowhere, I think, that I have come across conjures this up better than the Israeli Supreme Court. So when I went to the Israeli Supreme Court, my friend Ruthie was taking me there, and she took me to this entrance that you can see on the left. And I thought, and I said, Ruthie, we've come to the wrong entrance. This is not the entrance to a court, especially not your Supreme Court. This can't possibly be the entrance. You've taken me to the back entrance. She said, no, this is definitely where we go. So we go into this very small entrance, and immediately we see this stairwell going up. And having read Yosef Sharad, it was a brother and sister who designed this courthouse. We don't know how much it costs. It's never been disclosed. I think it was paid for by the Wilson Foundation. It's a beautiful courthouse in many, many ways. But the architects are intellectuals in the way that I think they only are. Where I see architects as real intellectuals is in France, where they really let their architects go rip on courthouses and come up with all sorts of concepts and ideas. This is a beautiful book that he and his sister wrote about the Supreme Court building, and he says that this was their attempt to actually prepare people for their journey of approaching the courtroom. They wanted it to be a small entrance because they wanted people to come in and then experience the sacred, if you like. And he says, one experiences a momentary doubt. Where am I heading? The eye, far swifter than the foot, hesitates bewildered. Perhaps there's an instant of alienation at the same time of reflection. This is a turning point. Either one retraces one's footsteps and exits, or one begins, like the space itself, to move towards the courtrooms. And at the top of these stairs, there is an amazing window, which is why my photograph is so bad, because there's so much light coming in, and there's a complete panoramic view of old Jerusalem. And this is the point at which he considers that you then turn towards law. So this notion of preparing people in a contemplative way and exposing them to beautiful scenarios in order to prepare them for what will be a fundamentally different experience from that of the outside world. So I'm getting very romantic here about all the things that architecture does, and please do call me to account in your question. But there is also a folly of romanticism in all of this. And I hear this a lot, I will say, from the legal profession in the UK at the moment, who have been very opposed to video hearings and to us going online. And on the one hand, I'm actually quite supportive of some of the things that they are saying, but I also think that they tend to romanticize what is going on in a lot of courts. So it seems to me here, when we're looking backwards, if we are looking backwards in terms of what we learn from courthouse design, we also need to appreciate the mistakes that we have made. And for me, quite fundamental mistakes in terms of inhibiting participation. So there are some sociologists who have talked about attendance at court as a degradation ritual, especially in magistrates' courts and the lower tribunals, those tribunals dealing with the poor, with social security claimants, with immigrants, that actually they are often much more understood, not in this grand, beautiful, aesthetic way that I have been talking about, but actually as degradation rituals. Pat Carlin, who's an amazing feminist Marxist who does not hold back on her criticism, also talks about these courts as being an exercise in theatrical autism, where the space undermines the attempt at any intimacy when people are telling quite personal stories of violence or rape or abuse. And she criticizes the space quite a lot and says that people just talk across the laity. And in my in my first book on court design, one of the things that I argue is actually, if we look closely from the 1970s onwards, we had that democratic turn in UK architecture, which finishes around 85, I would say, or 89. And then what we see is an increasing securitization of the courts. They become much more mundane than they were previously. We have no great architects building courts in the UK. They're building them in Spain, in Jerusalem, in Bordeaux. There is a court by Richard Rogers that's known as the Englishman's Revenge, because nobody there likes it. So we are exporting our architects. We do have architects who are quite thoughtful about court design. I would say Richard Rogers is one of them. but we haven't actually employed those architects in the UK. So we see a very mundane attitude, undermining some of these principles I was talking about from the late 80s onwards. And I have argued that actually we see courts as becoming increasingly undemocratic as we move into a mature democratic era. And I'm going to give you a little bit of evidence for that. I'm happy to talk more about this when it comes to questions. So, participation, due process, human rights, civil liberties, all the things that we associate with the latter part of the 20th century and the 21st century. And yet these are the courts that we are building in the UK. And if you think they look like castles, I think that's actually quite relevant. They do. It seems to me we have returned to the castle really in our courthouse design. Bolton Crown Court, I think, is an all-time low for courthouse design in the UK. Cambridge Crown Court is actually quite a recent court. It has very few windows, allowing air into people. And Guildford Crown Court has consistently been voted by barristers as the worst court in the UK. So I had an argument with a couple of architects over dinner one night because they were talking about courts being honest, courthouse design being honest. And what architects mean by honesty is that the material should be honest and you should be able to see the sort of building that you are entering. And I argued with him because he was just building a major courthouse in Brisbane, which is beautiful. And I said I thought this was the most honest court that I had ever seen, Bolton Crown Court, because actually if justice wasn't going to be done very fairly, if people weren't going to be treated with dignity, they weren't going to be given the opportunity to participate, that seemed to me the most honest court we could build. Because you look at it and you know something bad's going to happen when you go in there. Okay, so there is a danger of us hanging on to this notion of the courthouse as a special place. I think we need to remind ourselves that it can also be quite a degrading experience. Now, it's harder for me to show you photographs of the insides of courts because we have a ban on court photography in the UK, and all the images that are publicly available tend to have been done for a PR exercise, so show them in a nicer light. But I'm going to talk through the interiors of courts and the ways in which I think these have contributed to the courthouse becoming increasingly undemocratic by reference to a few images. So this image on the far left is one of the Wooden illuminations. It's a 15th century illumination. It is absolutely stunning. The colours are still very bright, and it's actually kept, if anyone is ever in London, at Middle Temple, and you can actually see it and touch it. It's amazing. And we think it was an image from the front of a law book from the 15th century. The book's disappeared, but we have 4 illuminations or images from the front. Now, I do accept that our civil liberties have increased enormously since this period, because you can see this is a criminal court. You can see that all these people waiting for trial are in chains. They've also got very long hair, which suggests they've probably been incarcerated for quite a while before they get in front of the court. And I don't deny that brutality. But what I wanted to draw your attention to was that we have the defendant here at the bar of the court, which in England, this is where the sense of the bar comes from. And we have the lawyer next to the client, shoulder to shoulder, lawyer and client. Okay, that was the norm. We also know that it's cut off in this image, but there are there's documentary evidence to suggest that the public walked all the way around in a U shape. They didn't go into the area where the judges were, but they walked around the outside of the court. And we've got an example of this in Chester Cathedral, which kindly shut the court down, their consistory court, for an hour so that I could take this photograph. And you'll see the idea that the people would have been around here, and the lawyer and their client would have been standing here. So this is what Claire Graham calls a sociable court, a court where the public jostle with other people in ways that we probably wouldn't think of as appropriate now for fear of intimidation. But the fact is that this was a very sociable court where there were likely to be lots of people observing the trial. It was noisy, but most importantly, lawyer and their client next to each other. So this is the representation of that court that was drawn by my friend Emma Rowden for our book, with the people moving around the outside. This is our most recent court design from our court design manual. Okay, so the important thing here, two important things here. First of all, the defendant in Crown Courts, which is our superior criminal court, is in a dock at the back of the room. Okay, they're not at the bar. They're not standing shoulder to shoulder with their client. They are separating their client. In fact, their advocate is 1, 2, 3 rows in front of them. Okay. Very common in English trial for the judge to have to tell the barrister that their client is trying to get in touch with them. So you have to sort of wave from the back, and then the judge has to tell you that tells the advocate that the client wants to see. The other thing is the public. The public are also segmented right at the back of the trial court. And I'll compare this with the contemporary US court, which of course is very different. We both come from the same legal heritage, but we have this very different court, much more like a Protestant meeting house for reasons I would be happy to talk about, and that is in fact its origin. But we have lawyer and client at the front, shoulder to shoulder. So it's interesting that this move has taken place in England. I think it suggests that we have become increasingly undemocratic in our courthouse, marginalising both the public and the defendant. And here we go as the final nail in the coffin, it seems to me, for participation in an English criminal trial. We have developed docs. We've always had the doc since had some form of place for the defendant for about 400, 500 years, but actually it was normally just a little stand. In Ireland, they call it the defendant's place. It's just you have a special place so that people can distinguish you from everyone else, but you're basically surrounded by observers in the courtroom. And the dock has slowly become a place of incarceration in English courts. So this is a magistrate's court, which is a lower criminal courts. And these are the secure docks, and this is a Crown Court. I like this image. It's a BBC photographer who let me have this photograph. This was on the day that this court opened only 10 years ago, because it really shows what the defendant will see. So apart from, I like to make the point with judges about how inhibiting it is to have this glass between you and the rest of the court by giving seminars where they sit in the dock and I sit up at the bench, and they get it within about 3 minutes. Okay. You can't hear, you don't feel part of what's going on. I haven't had many opportunities to do that. But there's research that's been done by David Tate and Meredith Wilson in the States, where they did a whole series of trials about how likely a jury was to find somebody guilty if they were sitting in a dock. And they did this for both this secure dock. We have a secure dock in every courthouse in the UK now, but also for what are called the regular docks, where you would get the glass would be about this height. Okay. And they found that if the jury thought, members of the jury felt that somebody was guilty, then where they were sitting wouldn't make any difference to them at all. But if they weren't sure whether somebody was guilty or innocent, then being in a dock made it twice as likely that they would find that person guilty, because they felt that they must be dangerous or a problem if they were somehow in this special area of incarceration within the courthouse. So we do know that this is having an impact. Countries like Russia and Italy are being brought before the European Court of Human Rights for putting people in cages. Challenges to this structure are beginning to gain some headway in the European Court. They've been slow to react to these because they look so much nicer than cages, but to me they have almost exactly the same effect. They deny somebody that sense of participation. So I'm sure we can do that much better if we go online. We also are increasingly segregating the public. This is something I'm going back to talk about to the Minister of Justice next week. Warwickshire Justice Centre is probably the worst modern example we have of this. You just have the public on top of the dock. They can't even see the defendant. They can't even look at the defendant's face to make their own determination of whether they think they are responding in a way that suggests they are guilty or innocent or showing any contrition. This is an image that my research assistant, Simon, drew of a court in Bradford, which was the bizarrest experience I've ever had as a member of the public. Because we were sitting here and we were looking at a wall. If you can imagine the way that the court is configured there. And then there was this smoked glass screen between us and the central area of the court. And what was bizarre was when you looked through that screen, the initial thing you saw before your eyes adjusted was an image of yourself, which I'm sure somebody much more clever than me, a philosopher, could make a lot of that. The fact that you look into the public sphere and all you see is yourself back. I'm not smart enough for that. But it was probably the most uncomfortable experience I had as a member of public, because it was really hard to see what was going on in the court, which seems, of course, to me to be one of our functions as a member of the public, to watch justice being meted out fairly. And the final point I would make in terms of us not being too romantic about what's happened with court design in the past is the security meet and greet. Okay, ubiquitous, it seems to me, across most of the developed world now. The first thing that the public experience when they go into the court is airport security. Good design can get rid of that. It's happened in the Commonwealth Law Courts in Melbourne and Australia, where Paul Casares, who designed it, has just created a separate little area that you go through for the security before entering the court. Okay? And yet most of our courts retrofitted have put in these security gates in the beginning. So the first thing that you learn about this public space, this civic space as a member of the public, is that you are potentially a danger or doing something wrong and you need to be searched. It seems to me we've lost all the glory of those salle de pas perdus when the first thing we do, or even when you see security guards in salle de pas perdus, it creates a very different image of justice from the one that I think those 19th century idealists were thinking about. So let me just touch base then and recap on what I've been talking about. So before I go on to the final part of the talk, I think we learn from history the importance of gathering, of the civic landscape, of courthouses as political symbols, as their power in rendering journeys to the courtroom more meaningful. But that there's also a lot that we need to learn about what we don't want to do as we take courthouse design into the virtual justice space. There are things that we need to be concerned about, not marginalising the public and not marginalising litigants or any members of the laity. So looking forward then, as I've said, in the city that hosts the Cyber Justice Lab, it seems significant to ask what design principles from the past we actually want to retain in the interest of facilitating participation, dignification and due process. Can we maintain a civic landscape when we go digital? I think that's a really hard one. Can we promote political and cultural symbolism in the public sphere? Less likely if we don't actually have one. But the last two issues I think are quite important for us as we think about design. Can we maintain a sense of thresholds and journeys to courts? I think my experience in the UK, we can do this so much better. And can we use technology to render legal spaces more open and democratic? Could the virtual courtroom actually do things better than the physical courtroom? And I think it can in some instances. So I wanted to talk about three positives and three negatives. One positive, I think, and we've learned this so much through the work in Cyber Justice Lab, fitting the forum to the fuss. Not everybody wants to go to a court, however beautiful, for a small scale dispute where there's high volume, there's little law and there's little money involved in it. If I have a dispute with Amazon, I really don't want to go to the local magistrate's court to deal with it. I'm happy to deal with it online. Horses for courses, it seems to me, fitting the forum to the fuss. And we've got examples of this, the money claim online system, get a divorce completely online now, no fault divorce. And also, I was talking to you about this a few minutes ago, Nicholas, the parking adjudicator, which sounds like the most boring tribunal possible. It's all about people making appeals against their local authority for giving them parking tickets. I'm fascinated by this because I think that Caroline Shepherd, who's headed it up for the last 15 years, has designed our most sophisticated online adjudication system, continuous dispute resolution. And again, I'm happy to talk about that. But what she has done, and I think this is significant because it shows that we can do some things better online, is that she has increased the number of people who are appealing against local authorities. So in terms of participation and people feeling that the system will do something for us, it's increased confidence in a very small part of the legal system. And she's done that in a number of ways that I would be happy to talk through, but basically a very well-designed online system that leaves people feeling very satisfied. So we've learned that not everybody who wants to come to court can do things differently in a way that's much more efficient for them. These three examples reflect some stuff that I found out recently in some work that I did during the pandemic for the government. The English government was looking for academics that could actually help them deliver public services in the pandemic. And I was fortunate enough to get one of these grants with my colleague Anna Salapatanes. And we wanted to do some work with the Ministry of Justice on exactly the point I've just been talking about, journeys to court. Since everything was going online, how do we actually improve people's understanding of what is going to happen in the online court, what it's going to look like, how they can prepare themselves, what they're allowed to do in the online court? Is it the same as them sitting in a regular courtroom? Now, what we wanted to do was actually just design a film that everybody would watch before they went into court, but the technology would not allow for that for a variety of reasons that I'll talk about. That's one of my goals in the future. So we prepared a film. We prepared 5 films actually for people who were going to be going to tribunals to help them prepare and think about how online would be different from offline. And I think they've been watched about 15,000 times now. We've just won an impact award for that work because it was, and all the judges are now referring to that in the correspondence that they send out to the parties. And we learned a couple of things. First of all, Social Security appeal tribunals. It does what it says. These are welfare benefits that people are appealing against a decision that's been made about the withdrawal of their welfare benefit. The judges in that tribunal told us that about 15% of people turn up to Social Security appeal tribunals. If they do turn up, they're 60% more likely to win their case, because they're often leading chaotic lives, but the judges can take them through and ask them questions which they think will help them present their best case. When they went online during the pandemic, the number of people turning up on their phone, it's not ideal, but on their phone, increased the number of people participating by about 48%. The Special Educational Needs and Disability Tribunal, the judges we work with there, told us that during the pandemic, kids with special needs whose parents were bringing their case to a tribunal to make sure that they had proper provision in schools for their needs were 40% more likely to turn up if it was online. So if you have a kid with autism or Asperger's, going to a court is a horrendously difficult experience for them. It's unfamiliar. They have to meet unfamiliar people. If they can sit in their room with a laptop or an iPad or even a phone and participate in the tribunal that way, they are much more likely to do so. And public participation, we got it really badly wrong in the UK during the pandemic, but it just seems to me that online has so much capacity. It does in the international courts. We see a lot of people watching those live streamed trials in the international courts, has a lot of potential to actually open up justice in a way that really speaks to the democratic deficit. We got it wrong because our judges are very suspicious of not knowing who is in the waiting rooms. That's something that we, or who's in the public gallery. That's something we really need to address. This is a screenshot from a 3-part experiment that I did with an NGO called Justice. And we got the free services of a technology company who wanted to work with us and thinking about, could we actually run a jury trial online? And the legal profession hated us for this. We got a lot of hate Twitter for this. They thought this was a dreadful thing. We were concerned that people who were on remand at the beginning of the pandemic, if their trial was delayed whilst we couldn't meet in court, that actually they'd be incarcerated for 18 months longer than they needed to be. So we felt that this was justified. We learned a lot about this. People often talk about technology creating a barrier between people, the idea of the cold screen. Actually, we found the opposite. We did surveys, a series of surveys after each of the experiments. The experiments were watched by about 600 people. A lot of journalists were watching us. And we found that the jurors actually felt that they could see everything much more easily, and that the defendant could see everything much more easily. Remember, in an English court, that the defendant normally sits with his barrister 3 rows in front of him with his back to him. Suddenly, they felt they could see their barrister and they could see everybody else. And the jurors were very positive about the fact they actually felt a proximity to everybody. Something else we found was this notion of gravitas. I talked a lot about the way in which buildings confer gravitas. What I learned during the pandemic was judges are absolutely amazing at conferring gravitas in the worst possible surroundings without any of the symbols. And they do it because they have a slower way of speaking, and they're used to pausing. And actually, online trials in the pandemic in England took longer than the average trial that was held in a building. And we think this is because judges were paying more attention to making sure that everybody understood what was going on. Now, that may change as they get used to online trials, but it was interesting how good judges were. They almost off the top of their head came up with these new speeches about online is just as important as if we were in a building. All the same rules apply. You will be listened to just as much. All the same due process safeguards. If you want to talk to me, you just put up your hand. And I wish I could have captured all those speeches. I asked the Master of the Rolls if he could help me gather some of these. I thought it was quite an important moment when judges were relearning how to do without all the pomp and circumstance, but to create a sense of gravitas and occasion in an online setting. I think that's been a really important finding. But there are still some things I think we need to do better. One of the things that we learned in the justice experiment is we tend to talk about an architecture of physical courts, but we weren't aware we needed to tell people about the architecture of the online courts. So people in the jury trial experiment got really concerned when people disappeared, or they were told they could go off into a meeting room with the judge because they didn't realise that there were other rooms, virtual rooms. And they also got worried if they didn't know who was in the public gallery because that was unseen for them, or they didn't know where vulnerable witnesses could be placed. So one of the big take-homes from that experiment was we need to explain to people who are engaging in online trials that there is actually an architecture that they need to understand. We need to help them understand that architecture so people just don't disappear. We've also learned, of course, a lot about digital disadvantage, and this is sort of the main focus of my research going forward. And some of you will, I can't remember her name now, Dorothea Langer, who in the New Deal in America took all those amazing art photographs of the poor. You remember the Dust Bowl photographs. And one of the, I did photographic history in my History of Art Master, and I was so fascinated that people were really disturbed. The poor who had their photographs were often really disturbed because they didn't realise before she took those photographs how much dirt there was in their house. She was using flash photography in hovels. They didn't realise how awful those hovels were because they couldn't see a lot of what was in there. And it seems to me there's something about online trials involving litigants who are poor that we reveal their poverty to them. We reveal their poverty and their disorganized lives to the world. We can't ask them to put up the screens that we all use when we've had a messy day, because the judge needs to know who's in the room with them in case there is anybody intimidating them or prompting them to give certain answers. And you can't see it very clearly. This bottom image is an image that we put in our films, suggesting to people that they might just want to make sure what was behind their screen when they were in the trial. And given that we were launching these films with people that were Social Security benefits recipients, apart from others. And we said to them, because it's something that I would have said to my clients when I was a practitioner, you know, just tidy yourself up a bit, just make sure you look smart, just put on a black jacket, borrow a jacket. In fact, the firm I worked in, we used to have black jackets hanging up so that people could appear in court. People reacted so violently to this. And we did a lot of focus groups in food banks outside in car parks. We couldn't gather, we weren't allowed to because of government guidance during the pandemic. So we did them under gazebos that we bought with our research grant in car parks, and ran these films past people who had experienced the justice system. People felt very, very strongly about this. Probably the most contentious thing we did in the films was to advise people about tidying up the background. People felt patronised, felt we were judging them. Now, the good lawyer in me felt I'm preparing them for justice so they can make a better impression, but they didn't think that it should matter what their backdrop looks like to the judge, and of course it shouldn't. So there are tensions, I think, and things that we need to handle very carefully. We also, please, any engineers in the room, please, 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 we have made much more complex the journey to court for the digitally disadvantaged. So I've done a content analysis of all the guidance that was issued by our judiciary during the pandemic, and these are things that are expected of people before they can get into the trial. They need to install software or test their ability to participate in the hearing. They need to ensure they have a stable connection and a minimum bandwidth. They need to share files using links to Dropbox, OneDrive, or Google Drive account. They need to use a side panel for messaging. They need to mute their microphones when not speaking. They need to have you get the idea. So when we're thinking about journeys, I was thinking about journeys in a very positive way of calming people, giving them a sense of the space, letting them get to the waiting room as long as they want to in advance, so that they can sit and see what's going on in the hustle and bustle outside of the courtroom. Those all seem to me to be quite important things. What we found is that for people who were digitally disadvantaged, that just added an enormous layer of stress. If you care to watch our films, there's a link to them at the end. One of the things that we tried to do was just really slow down the process of explaining to people what was going to happen and try and create a calm environment for them. We were told initially nobody would watch 15-minute films. When we tested them out with people in food banks, they said if they were going to a tribunal the next week, they would watch that film 10 or 15 times to get themselves ready. 2 judges said to us, after hearing the films, they felt relaxed at the end of the day. So there are things that we can do to start creating effective journeys to the courthouse that undermine this sense that people have of not understanding the technology. Now, I know, Nicholas, you're going to tell me this is all bad practice and it's not going to happen in cyber justice, but this is the sort of, I think, challenge that we have in working with people that are only technicians in doing some of this stuff. So here I'm finally ending, and my apologies, I'm over time. In conclusion then, I think learning from the past, there's a lot to be said about the importance of the civic sphere and how we address that in a society in which we are really concerned about democratic deficit, as anybody who had Boris Johnson as a Prime Minister would be. We've got to be honest about what has been achieved and what hasn't been achieved, okay, to get over that sort of romanticism. I'm an academic, so I'm going to say this, but I think we desperately need more user-led research with appropriate methodologies. And I've just written a piece with Anna Salapatanis on who do we need to exclude from online justice in the interest of including them in the justice system. I'm thinking about the thresholds that people need to satisfy before they're actually able to go online in the first place. And I think we need more user-led research. For my money, our Ministry of Justice does not know how to get at the digitally disadvantaged. They've sent a survey out to them recently, an online survey, and then they noticed that not many people were responding to the online surveys. They sent them out paper copies. Now, we all know that digital disadvantage is a compound disadvantage, and it often maps on to economic and social exclusion. So those people probably might have found it difficult to deal with paper. And we know that a lot of people who are seeking asylum don't sign pieces of paper routinely. They are distrustful of paper. So I think we need to, as methodologists, we need to think really intelligently about how we actually access the digitally disadvantaged. In my view, we need to think really seriously about support hubs for people, local support hubs in a time when courthouses are being shut down across the UK, thinking about reopening some of those libraries we closed a few years ago, and establishing support hubs where people can go to be assisted in engaging with an online court. We found in our study for justice that as long as you took the technology problems away, if you had people there to assist jurors in entering, they really enjoyed the experience of being a juror. It was when you we took away their keyboards, we took away their mouses, We just put 2 screens in front of them. We had a technology technician nearby to help them. As soon as we took away that concern, they could really engage in the process. And we've got one of our postdocs at the moment in the Oxford Centre for Social Legal Studies observing how people use information desks in libraries, IT support desks in libraries, what sort of interactions with the state they're dealing with. I think we need the state to think seriously about the provision of equipment. A technology firm, AVME, we worked with, said it's very easy to get an iPad out to somebody and enough internet connection for them to comfortably join online. But I think we also need to recognise that there's something called situational disadvantage, or what I call situational disadvantage in the legal system. People are nervous and scared, however skilled up they are, by reason of being in the legal system dealing with somebody in authority. It's not just those who don't have digital skills who get scared in the justice system. So I think it goes beyond kit and training and whether or not you can get sufficient bandwidth connection. I think beware the techno-evangelical who tells us that technology can deal with anything. I think anybody who deals in technology never takes that viewpoint. And I think we need more user-led design involving multidisciplinary teams. It was really important in our Supporting Online Justice project that we were talking to people in food banks and judges. So every time judges told us they thought we needed to do something, we said, well, when we talked to the people in food banks about that, they said that they'd be really worried about it. So judges wanted little clocks. It's 10 minutes before you're going into your hearing. The clocks completely stressed everybody out. They didn't want to sit and look at a clock. They want to be told you've got time to go make a cup of tea and then come back. So I think those user-led design involving multidisciplinary teams and not just professionals is really important. So I'm going to stop there, but I'm just going to leave you the screen of some of the resources I've been referring to if anybody wants to chase up about them. So thank you.